May it please the court. My name is Alexander Scott Dennison, and I'm here on behalf of the appellant, Charles Channell. And we're here on the appeal of a final judgment of mortgage foreclosure, and there are several issues that I'll be arguing give rise to the final judgment being overturned. I'd like to start with the argument concerning the condition precedent of notice under paragraph 22 of the mortgage. Specifically, the document I'm referring to is on home ec servicing letterhead, and I'd like to explain to the court why, based on this argument alone, the plaintiff failed to carry its burden below. And then we'll get to the other, and I apologize, Your Honor, I would like to reserve 5 minutes for rebuttal. The law on paragraph 22 has been the subject of recent cases in most of the districts here in Florida.
I think there's some lawyers' boats named.
I'm sorry?
I think some lawyers have boats named paragraph 22.
I hope they invite me out sometime,
Yeah.
Your Honor. That's great. The issue with this letter, and I'd just like to walk through them briefly, with the actual document itself failing to comply with the terms of paragraph 22, and then the admission of the document being improper as well. Paragraph 22 requires that very specific notices be provided. It's the only paragraph in the uniform Fannie and Freddie mortgage that's in bold. To argue that these terms are somehow less important than other terms which aren't in bold, for example, like the amount of payments and when they're made, those aren't in bold, but these are, I think is a disingenuous argument. These terms are as important as any other in the agreement. The language requires, number one, that the notice provide and identify what the breach is, the default. And this letter doesn't even identify specifically which payments were allegedly missed. And it says you're hereby provided with notice that you're in default under the terms and conditions of your note, retail, installment, sale contract, and mortgage deed or trust secured by the above referenced property for failure to pay the required installments when due. It doesn't identify at all which installments were missed. So that's one item, and I think that's enough for this letter to fail on its face.
Well, down in the...
I'm sorry?
In the second paragraph, there's a reference to August 1, 2009.
There's a reference to August 1, 2009, I agree, but it still doesn't identify which...
As of the date of the set of the amount required to bring the account current and avoid foreclosure is the sum of payments that have come due on or after the date of default, August 1, 2009. So isn't that a reference to when the default happened?
Respectfully, I can't tell what it's a reference to. It says if there was a date of default, it just doesn't specify which payments were missed. And then moving on in that paragraph, Your Honor, just kind of walking through this, paragraph 22 also requires that the borrower be informed of what's required to remedy the default. This doesn't get there. This language in this paragraph gives the borrower a phone number to call to find out what amount is due to remedy the default. That's not something that is provided for in the contract. It states very clearly, as of right now, this is an amount that's due. That's not the amount to cure the default. It says because interest accruals, late charges, etc. May accrue, you should contact Home Ec at this 800 number. So there's another reason that this specific notification fails to meet the contractual requirements under paragraph 22. The next issue in the letter that fails to meet the requirements of paragraph 22 is that there's specific language requiring that the notice provide that the borrower has a right to bring certain defenses to the default. as a defense to the foreclosure action, that's mentioned nowhere in this letter at all. What's mentioned is you may have a right to bring a lawsuit. So there's no mention of raising defenses to the default in the foreclosure action as required by the letter. So there's at least three issues that cause this letter to be facially defective. The next issue I'd like to address is the admission of this letter, since we're on the letter. And there's also an argument related to the Business Records Foundation, which I'll get to in a minute. But this letter specifically is on home ec servicing letterhead. Presumably, we would look at this and assume that the party, if it was sent, that sent out this letter was home ec servicing. There was no witness at trial to authenticate this document. This document was admitted purportedly as a business record of Ocwen. There was no evidence from the witness to indicate where this, how this letter came into the possession of Ocwen, how somebody that was an employee of Ocwen would have any information that would give them the ability to authenticate such a letter at all, certainly no personal knowledge. So I think the admission of the letter was also an error, but even with that error, the letter on itself fails to comply with the requirements of paragraph 22. Shifting to the next issue I'd like to address, and that is this issue of attorneys testifying. And this is something in the trial practice that happens, well, it's happened every trial I've been in, where the attorney stands at the podium, reads from a script, and the witness agrees or disagrees as required to provide the facts relevant to the case. And something struck me as odd about that. In a review of the case law, I was not able to find a lot of civil cases that address the issue. But I did cite to U.S. versus Bryant, Stein versus Marathon Oil, and Porter versus State. And my concern, I think, was highlighted in Porter versus State in footnote 3. And in footnote 3, the court cites Professor Whittemore's treatise in this story of an after-dinner trial at the Old Bailey that the court recites the whole thing and says the trial lasted 2 minutes and 53 seconds. The witness said, "Yes, sir." That was the testimony provided. And the prosecutor provided the entire narrative, and the trial was over. So I think there's a balancing when we're looking at attorneys testifying and, excuse me, and leading questions. And in this case, there were 62 questions asked. The witness spoke on average 2.48 words per answer. And if you read the transcript and you only read the witness's testimony, it really doesn't provide you any story on its own. And the case law I cited in the briefs, the key point is that there's some facts in any case that should properly originate from the witness and not from the attorney. And the example from the Porter case, I think, is illustrative of why that is the case. If, as attorneys, we can provide the narrative, we can argue the case, as the courts have said, and provide all the facts at the same time. And that's the purpose of prohibiting the leading questions. The attorney spoke a total of 779 words, or 12.56 per question. And as I cited in my briefs, the majority of the answers from the witness were yes, that's correct, yes, that's true, no. There were very few statements by the witness at all, which leads me to my next issue, which is to lay the foundation for the business records exception. The test requires that the elements of the test be demonstrated, not recited. If all we had to do as lawyers is just recite a test, we could convict people in court all day long. But we have to go beyond that. We have to demonstrate with credible evidence that the elements have been met. And I think that what we saw in this case certainly was a mere recitation of the elements of the test for business records exception to the hearsay rule, and agreement by the witness that this was the case. The witness provided no facts as far as any personal knowledge, simply just nodded and said yes or no as appropriate. The danger there is that, as the courts have said, it might provide the witness a false memory. In fact, I think the court below even mentioned, in response to one of my objections, that the witness may refresh her memory when reading from a document of the lawyers. But for purposes of the business records exception, the foundation was not laid. There was no evidence in the transcript that those elements were met. They're simply just a recitation of those elements, which is improper. In fact, in response to the question, are the records made by a person with knowledge at or near the time the events occur, on page 5 of the transcript, there was not even a yes or no in response from the witness. So I think it's clear from the case law cited that it's not enough just to recite elements of a test in order to prove your case. There has to be some credible evidence. And my whole point in the case below, which you probably saw, I didn't cross-examine the witness. I said to the court that the plaintiff hasn't met their burden, and I didn't feel it was my responsibility to assist them in doing so. They simply failed to put on evidence to support their prima facie case for mortgage foreclosure, and as such, it's my position that the final judgment should be overturned. The next issue I'd like to address was addressed in the 3 motions to dismiss that were filed in this case. And this case was unique in that we had a very, very extended pre-answer time period in this case. And on my 3rd motion to dismiss, without explanation, the court, with the same issue present, denied my motion to dismiss and then set the case very quickly for trial after my answer was filed. Previously, the motions to dismiss were granted because the complaint, frankly, failed to state a cause of action. There were no documents attached to the initial and the amended complaints that showed that there was standing at the inception of the case.
On that issue, ultimately there was a copy of the note, or there was a note with an allonge attached.
There were, and that creates a conflict, I think, in the chain of title.
Right, and was there ever any evidence of the date of that allonge? Because there's not one on it.
No, and my argument is the allonge would fail anyway, because an allonge has to be physically secured to the note and attached. That's the ancient law of merchant. You have to have the document physically attached to the note. Initially, it was designed so tradesmen could do business in large amounts of sums without having to carry cash. And if they ran out of room for endorsements, they could attach another piece of paper physically to that.
And remind me, because as you well know yourself, we have a lot of these cases, and so it's easy to get the facts confused. But by the time that one was attached to a complaint or produced,
it was never attached.
Never attached to a complaint. Had the note already been filed?
The note was filed in the case sometime in 2011.
And the allonge came up when?
I believe the allonge was attached at the same time, Your Honor, and
at that time.
I don't have that
okay.
At the tip of my tongue. But the issue I'd like to point out to the court on this is that at no time was that attached to the complaint as required by the Florida Rules of Civil Procedure. They could have at trial moved to conform, just for the sake of argument, the pleadings to the evidence that was presented, and asked the judge to rule that the complaint, the document was attached to the complaint as required. But as it stands, the complaint they were writing on, it was never attached to that because it was filed in the court file. So I think procedurally the case, the final judgment was issued upon a complaint that failed to state a cause of action because it violated the rules of procedure.
Mr. Dennison, you're at 5 minutes remaining, so do with them what you want to do.
Thank you, sir. Just one thing, and then I'll leave the remaining time for rebuttal, and that is the issue you raised regarding standing at the inception, the fact that an assignment of mortgage was filed, but there was no evidence at any time attached to the complaint showing that when the case was filed that the party had the right to do so. So I think that that's problematic. I think that the other issue that's raised, which is a fact issue, is the issue you alluded to, sir, is that there is an allonge in the file which purported to transfer an interest from the original lender to another party. There's also an assignment of mortgage in the file that purports to transfer an interest from the original lender to the plaintiff below. How do you reconcile those? I think that's an issue of fact that wasn't addressed.
Do we have evidence of the dates of those?
That's
as compared to the
that's my
filing
point.
of, I mean,
It appears of the record that there's a conflict between the evidence that they submitted to show that they had standing, and at any rate, it did not show that they had standing when the case was actually filed.
Thank you, Mr. Dennison. You have about 4 minutes to go.
Thanks.
Good morning. May it please the court, Diana Mattson, representing the appellee, Deutsche Bank Trust. I will address some of the points that Mr. Dennison just made, but I'd like to first start off by saying that initially my feeling was that I intended to rest on our brief regarding the first and fifth arguments that he made in his brief, which were the issue of the leading questions, what he calls as the attorney testimony, and that the note was not negotiable because I feel that the law is pretty clear that the type of question that requires a yes or no answer is not necessarily a leading question, and I think the judge in this case during the trial recognized that and tried repeatedly to advise Mr. Dennison that that doesn't make it a leading question. So I'm not going to address those in detail because I think the other three issues require more time than we may have. First, I would like to address one of the points that Mr. Dennison did make in that he didn't cross-examine the witness. And in fact, he told the judge that he didn't think he had any obligation to because it would help plaintiff's case in chief. But I would, based on the case law, I would suggest that the Florida Supreme Court would disagree with that. And we do cite to Goodwin versus State and Jackson v. State, which are both Supreme Court cases on the issue. And they stand for the proposition that the defendant bears the burden to demonstrate error and to preserve the issues for appeal. And the way to do this is to make specific and contemporaneous objections to the admissibility of evidence. And the purpose of this is to allow both the plaintiff's counsel and the trial judge, the plaintiff's counsel to correct the error, to make an attempt to correct the error, to bring the witness back and redirect, and the trial judge to then make an informed decision. By not cross-examining the witness, Mr. Dennison failed to demonstrate error. At no point during the trial did he put the judge or plaintiff's counsel on notice of any of the defects that he discussed here today. He mentioned prior servicer testimony. The words prior servicer do not exist in that transcript. It was never raised. His objections were vague and never specific. And in most cases, they were untimely. Only in one objection, and that was to the payment history, did he even mention the words business record. And then it was untimely because the plaintiff's counsel continued to question the witness to complete the foundation for the business records exception. And when it came time to admit the record into evidence, he did not make specific or any other objection. So appellee's position is that because he never made specific and timely objections, all of the objections to the admissibility of the evidence were not made and not preserved for appeal. And these objections include all of the objections that he made to the inability of plaintiff's counsel to lay the proper foundation. Again, specifically with regards to the prior servicer, lack of foundation in particular, that was never raised as any in connection with any of the objections. The only time the business records exception was even mentioned, and that was just by stating the business record, nothing else, was in regard to the payment history, which included both Ocwen's loan history and the HOMEC, who was the prior servicer. And I'd like to just point out, too, that even in some of the cases that he relies on for the lack of foundation, including the Yang case, Glarum, and Specialty Linings case, in particular, they're distinguishable because for the very reason that in each of those three cases, there was extensive cross-examination by the defendant's counsel, which brought to light the defects and the deficiencies in the plaintiff's testimony. In this case, because he didn't do that, the judge never heard anything except the positive testimony by the plaintiff's witness in the case. There was nothing to contradict anything that she said. And this puts the court at a disadvantage because the court's not able to resolve the issue of whether or not there's an error. Even if he had made a timely objection at the time the evidence was being submitted, which he did not, the trial court would look at the evidence that was presented and not see anything objectionable. In Yang, in particular, it involved a condominium association as the defendant, so it wasn't a prior servicer, but it was analogous because it was an accountant who had taken on the records of a prior accountant. And Yang, again, reminded us that the objection must specify the legal ground on which the claim is based, and a claim different than that cannot be heard on appeal. He never raised any of these objections at trial.
Did he object to hearsay?
He mentioned hearsay, I believe, with regards to the original note. He said hearsay with nothing more. And the objection to, there was one other one. The demand letter, again, he mentioned the word hearsay, but again, nothing regarding prior servicer, current servicer, business record exception, nothing, just merely saying the word hearsay.
So, business record exception is not an objection. The business record exception is how you get around the hearsay objection, and it would be upon the proponent of the evidence to lay the foundation.
Right, and our position is that this attorney did lay the proper foundation for the Ocwen witness to testify as to Ocwen's records.
As to their own records.
Correct.
Not to records of the prior service.
No, there was no testimony regarding the prior servicer because there was no cross-examination of the witness to establish that she didn't have any knowledge of the prior servicer.
No. The proponent of the hearsay has to lay the foundation. Whatever the prior servicer did was absolute hearsay, correct?
Correct.
And there's a hearsay objection, and you want to get that in, you have to lay that foundation yourself. It's not up to him to cross-examine on that.
Well, I think in terms of the demand letter wouldn't necessarily be hearsay because it's just to show that the demand letter existed, and it would come in as a statement. But
can we not get to some of the evidentiary rulings here based on 1.530E? As Wolkoff opinion this court pointed out that when an action has been tried by the court without a jury, the sufficiency of the evidence to support the judgment may be raised on appeal, whether or not the party raising the question has made any objection thereto.
correct.
So can we not look at the foundational requirements based on that rule?
I agree that this, yes, under Wolkoff, you can.
If
The
we
objection.
can look at it, and I can measure the predicate foundation here against the 4th District's recent opinion in Bank of New York versus Callaway, there doesn't appear to be much information to tell me what records this witness knew, where they were kept, how they got any knowledge. All they said was yes, and there's no development. There's no facts. Their opinions, did you look at the books and records? Yes. What books and records that you look at were never asked? Never testified, they examined the prior records to show they had any authenticity in them, that they are the type of records that a business would rely upon. I mean, this is a pretty scant foundation, if it is in fact is a foundation. And I realize reading the transcript, it sounds like the trial judge was a little irritated at the objections. I understand that.
Well, and understandably too, that, you know, it's hard to put yourself in the place of a trial judge who may have 30 or 40 trials in a morning and with time limitations and, you know.
Yeah.
Right, so.
You know, in
so
Lee County, they have the
because-
rocket docket. We're familiar with what's been going on.
Right, so from the judge's standpoint, he didn't hear any negative testimony. He only heard positive testimony about the records, and because the witness did lay the predicate, the foundation for the ability to testify as to Aquin's records, there wouldn't have been any reason for the court not to consider the demand letter, because the way the questions were worded to the witness was this was Aquin's record. They took over for home ec. They established it through the power of attorney that they were the subsequent servicer for home ec, and that may have been sufficient. And I don't necessarily agree that it would have been an abuse of discretion for the judge to consider that based on the testimony that was given. And the other thing is that in the Wolkoff case, the result of the deficiency in the evidence was a reversal and a dismissal, and I think that's what counsel is seeking in this case, although he doesn't
Judge
specifically.
Black has helped us out there on the recent Colson opinion.
I was just going to get to Colson. Colson is because almost all of the cases that even defense counsel relied on are situations where there is a dismissal, is situations where a motion for directed verdict or a motion to dismiss for involuntary dismissal was made at the close of the evidence.
For a delay or something for the sale date, or I forget. There was
correct. There was no, again, not in addition to the lack of cross-examination to bring the errors to the court's attention, there was never a motion to dismiss or for directed verdict made. So the court never had the ability to address the issue whether it should be done at all. So because it wasn't made before, and I think Colson clarifies that, Wolkoff, although it doesn't state it in it, they reviewed the records again, and there was such a motion. And in all of the cases that I reviewed, the only instances where there was a reversal and a dismissal was where there was that kind of a motion made. That just wasn't done in the case. So that issue is not before the court. I don't think, even if the court is inclined to say that the foundation wasn't laid properly or that wasn't sufficient, especially regarding the prior servicer, the remedy might be a reversal for additional testimony, a new trial, but not for dismissal because it's just not warranted in this case because no motion was made below. Also regarding, I'm not sure that it will have any effect at this point, but in terms of discussing standing, the court questioned the allonges and the assignment. The assignment was never admitted into evidence, so although it was produced in discovery. The assignment of mortgage did in fact predate the complaint. Again, it wasn't used as an exhibit at trial.
How about the allonge?
The allonges were attached to the original note that was filed in 2011. There were two allonges, one from the originating lender.
Case was filed when?
I'm sorry?
When was
About 4 months before that. So when the case was...
Is the allonge dated?
The allonges are not dated, no. But what we
So
have...
do we have evidence of when the allonge was attached to the note?
No, because the second amended complaint, Mr. Dennison said that the complaint had the same issues in it, but I would differ. I would not agree with that because the original complaint and the first amended complaint, both the allegations for standing just said that plaintiff is entitled to enforce, and that was insufficient. In the second amended complaint that was filed, which did have the exhibits attached, including the original note, a copy of the original note with the allonges, the allegations for standing said owner and holder. So by virtue of pleading owner and holder, they could have proved at trial that they were either the holder or the owner. If they wanted to prove that they were the holder, they would have had to have evidence in the court about when those allonges, either when the allonges were signed or when the physical note transferred possession from the original lender to the trust. That the plaintiff conceitedly did not do, but what plaintiff did produce...
Isn't there a case because you didn't do that, you have no proof of your standing at inception?
If you're going based on Holder, but there's a case law that says you don't have to prove both, you can prove one or the other.
Right.
And what we have here in terms of evidence that was before the court is the demand letter, because the demand letter is unique in that in addition to complying with paragraph 22 and hitting all of the 5 elements that are necessary in terms of notice, the demand letter also stated that
Deutsche Bank was the owner.
I'm sorry?
Deutsche
Exactly.
Bank was the owner.
Deutsche Bank, the
Was
trust.
the demand letter dated?
The demand letter, yes, was dated, it was sent,
No, when it was dated?
it was dated July 15th, '09, and the complaint was filed on September 20th, 2010. So,
So you say there's an inference that can be drawn?
correct.
Because
It's,
that is hearsay, that letter.
again, a different issue, but, the letter was admitted, the judge reviewed it, and it specifically identified HOMEC as the servicing agent for the owner, and it says owner, creditor owner, and it specifically names the Deutsche Bank Trust. So there's nothing in the court that the court had to look at that was in any way contradictory, in direct contrast to some of the other cases where there may have been a launch to or an endorsement to a completely different entity. Everything here was consistent. The power of attorney specifically stated that Ocwen Loan Servicing was taking over for HOMEC. HOMEC was identified in the demand letter that predated the complaint. There was just nothing contradictory. There's nothing to put the court on notice that there's anything to support a position that the plaintiff didn't have standing. Oh, and just in terms of my last statement about the counsel tried to rely on the Lacombe case in his reply brief to support his argument that plaintiff didn't prove standing. And I have to say that in the initial brief, there was absolutely no case law on his argument that the plaintiff lacked standing. So it didn't come into play until the reply brief. But Lacombe is the case. It's out of the 1st District, I believe, where the court was faced with an allonge that had an endorsement to a completely different entity than the plaintiff and no other explanation. In addition, there was extensive cross-examination that, again, put doubt into the credibility of the witness. And this court gave Mr. Dennison 2 opportunities to cross-examine, and each time he said that it's not his duty. And I would, again, tend to differ that the Supreme Court says that it is his duty to bring forth the errors to the court so that they can rule on it. So that appellee is requesting an affirmance of the judgment. If the court is inclined to believe that there was an insufficiency of some of the evidence based on hearsay, because no motion to dismiss was made, that we would request a reversal and a remand for new trial or additional proceedings.
Thank you.
Thank you.
I just would like to respond briefly to a couple of points and thank Judge Casanueva for making my point about the issue with the plaintiff's failure to make their case. It's very clear that there is no objection required. It is the plaintiff's duty to carry their burden, and to attempt to shift that to the defendant is just not within our system of jurisprudence. I'm not familiar with Your Honor's opinion in Colson, so I'm not sure what the facts were there. There were 3 motions to dismiss filed in this case. So if the issue is that there was no motion for a directed verdict, I think you can get a sense of the tenor of this trial from the transcript, and I won't say any more than that about that. demand letter being dated, I thought was a very interesting discussion. I'm not quite sure, really what to think about that. We sue on notes, we sue on mortgages. There are certain things that give us rights to enforce obligations, to prove that a party has a certain status, but an unauthenticated document, I could understand if it was something that was self-authenticating, a matter of the public record, such as an assignment of mortgage or something like this. But I'm not real sure where the argument about the letter providing some indication of standing at the inception comes from. So I'm not really sure how to respond to that, frankly.
Well, I think the idea is that you've got you got every indication that Deutsche Bank has an allonge at one point, and then you've got a letter that predates the filing of the suit that says Deutsche Bank is the owner. And so I think that what the plaintiff is depending on is an inference from that evidence that Deutsche Bank owned the note prior to the filing of the suit.
Well, I see. As far as authentication goes, we don't know because that document wasn't produced until the Friday before the trial, when it was even produced. So it's certainly not self-authenticating. Based on the totality of the argument presented, I would have loved to have presented it more eloquently, but I think that the court can see that, based on the failures of the notice letter facially, that this case, that the final judgment should be overturned. Based on the other issues, I encourage the court to consider this issue of counsel testifying. I think it's fundamental to our judicial system. I think it's a very important issue. I think that simply coming in and reciting elements of a test does not meet our burden of proof in our judicial system at all. I think that, as Judge Casanueva said, there needs to be some development, some narrative provided by a witness that can provide the court the opportunity to judge the veracity of the witness. It's certainly not the defendant's duty to do that. And as such, I'd request that the court overturn the final judgment below and dismiss the case. Thank you, Your Honor.
Okay, thank you both. Court will be in recess for 15 minutes.